Thank you, Parisa. And actually, all credit is due to Empower DC and to Parisa Nuruzi, who has labored long and hard in Ivy City for the past decade. Long before I ever showed up, Parisa was there rallying the troops, encouraging the residents that there was a tunnel's light if they just stay the course. And eventually we have those efforts. And again, let's give Parisa a rousing round of applause. Those efforts have borne fruit, we believe, and that's what we're here to discuss tonight. I'm going to ask each panelist to speak for 10 minutes, and then we'll engage each of you. I won't take a full 10 minutes, but I'll call next on Gary Kopff, and Gary will introduce himself, and then I'll call on Gottlieb Simon, and he will introduce himself, tell you why it's important to listen to him. And we're expecting Professor Jason Newman, and he'll go last, since he's last coming, and he'll introduce himself and speak for 10 minutes, and then we'll have a discussion, if that works for everybody. But I just ask you to transcend the muddy waters of history with me, if you will, to a bitter, cold winter day, Christmas Eve of 1973. And I was enjoying chestnuts roasting by an open fire.
Right.
And the telephone rang. It had rang earlier at Professor Jason Newman's home. Jason got a call from John Dean. You remember him, Deep Throat. He was counsel to President Richard Nixon. And John Dean said to Jason on Christmas Eve of 1973, the president is going to sign the Home Rule Act today. A lot of folks didn't know Richard Nixon signed the Home Rule Act. He said the president's going to sign the Home Rule Act today. Whereupon my telephone rang. And Jason said, Johnny, you got to go to work. You know? He called in. So I remember Christmas Eve of 1973 because we worked that day. And we produced a little yellow and red booklet that explained to the people of Washington, D.C. what Home Rule was about and what advisory neighborhood councils, is what they were called at the time, was about. Because the voters had to vote on both, whether they wanted Home Rule, some called it Home Fool back then, as you recall, and whether they wanted advisory neighborhood councils. Ultimately, they voted favorably on both. So after we produced this booklet and shared it with the community and went around explaining Home Rule and ANCs to everyone, we then had special sessions for the newly elected advisory neighborhood council people. And in the room at that first session was none other than Gottlieb Simon. And Gottlieb Simon has been in the room ever since then, coordinating advisory neighborhood commissions, they're now called. So we're very fortunate to have Gottlieb with us. And in time, another early advisory neighborhood council person was Gary Kopff, who felt as we did at a program at Georgetown University Law Center called the DC Project on Community Legal Assistance, that the local government was not carrying out the intent of the ANC statute. Of course, people believed that the local elected officials felt threatened by these mini city halls and small units of government. And so they did all that they could and would to suppress the power and influence of ANCs, to the point that, as I said, many of us believed that they were not carrying out the true meaning of the statute that created these entities. And Gary Kopff carried that torch to court and came out with a resounding outcome in 1977. And so when he'll talk about the Kopff case, which has been the beacon of light for so many advisory neighborhood commissions since 1977. And it is our hope that now with the Ivy City decision, we are moving back closer to that Christmas Eve of 1973, when we believe the ANCs would have a significant and important role in decisions that affect all of us, quality of life decisions. And so with that, just as an introduction, I will turn the floor to Gottlieb Simon for 10 minutes. I have my stopwatch with me.
All right.
Excuse me, to Gary Kopff for 10 minutes. I'm forgetting the rules. That's what the D.C. government does. They ignore the rules and they ignore the law. That's right. That's right. Gary Kopff, that's the rule of law. Go ahead, Gary.
We're going to go back 5 years before that evening that Johnny just talked about. In 1968, 45 years ago, I came to this city, and I came with a background of spending a little bit of time in Colorado, where I was born, in Denver, in Connecticut, Yale, and in Ithaca, New York. So I lived in 3 communities. And I want to ask, how many of you in the room have lived anywhere other than Washington, D.C.? Okay. So you have a concept of what it means to be in a city, or maybe an unincorporated area, and in a state, and have representatives in the Congress who you vote for and they vote for you. But you've come to a city like I did 45 years ago that was a little bit different. I came to this city to work for Mitt Romney's dad, the other Romney, for those who remember him. And I spent 6 years working for him and his successor at the cabinet level position for housing urban development. During that period of time, just before the night that Johnny alluded to, I was reading some legislation as well. Because one of the things that I had in my portfolio in the Secretary's office was the DC situation. I wasn't an elected official. I had no reason for such a situation, except that was one of my assignments from the governor. So I worked with the Nixon White House and with other parts of DC government. I worked at the Federal City Council and the Group of 100, Pennsylvania Avenue Development Corporation. I sat with their board of directors at their meetings. And I'll come back to that in a moment for what it implies about the Union Station Redevelopment Corporation. And when the legislation came through, I read it with much interest. And I particularly read with interest Congressman Frazier from Minnesota and the amendment that he put into the home rule legislation. For those who don't remember Congressman Frazier, he was the former mayor of Minneapolis before he was a member of the Congress. And he looked at the home rule situation in Washington and its history and thought, we have no concept of what it's like for the citizenry to run their city / state perhaps one day. So he put in this section for ANCs into the home rule legislation. And I thought that was very perceptive. But Congress, then as now, has a multitude of views. Some people looked at the District of Columbia and said, wait a minute, those people out there, what if they use this legislation and get into court? How do we keep them constrained, if not working through the executive branch and maybe the legislative branch as city council builds up its power? But let's not let them into the third branch of government, the judicial branch, or they'll be clogging the court system with litigation against the executive branch. So they wrote in legislation, which Frazier did not advocate, but others did, saying ANCs lack standing to sue in court. And that was part of the legislation. So that was the first time that there was a bit of an evisceration of the powers that were going to go to ANC and in turn to the people, to whom ANC is much closer. Then, after the home rule legislation in '73, the city council had to pass legislation, the ANC legislation. And the city council took evisceration just a little bit of a step further. And they said, all right, well, policy decisions have to be subject to the notice and the great weight, but let's constrain it there. And the Corporation Council, now called the Attorney General, wrote an opinion, and that opinion was examined carefully by the council in the Kopff versus ABC Board case. And the Corporation Council was a little worried the same way. Maybe we better curtail this thing a little bit so it doesn't get out of control. When the Kopff versus ABC Board case hit the appellate court level, they took a careful review of the Corporation Council's opinion and said, he's gone too far. He's pulled back on authority that we intended by saying only policy decisions. And they had a broader concept. And that concept, as it was laid out in the appellate decision, said, if there's a public hearing required, isn't that a significant indicia of public interest and purpose that also requires the ANCs to have great notice? So they basically backed away and put down the Corporation Council's ruling and broadened the rights a little bit. 45 years went by, almost 40 years since the Kopff case, and we again have a situation where a member of the judiciary is opining on these issues that affect all the ANCs and all the citizens indirectly through their ANC commissioners. And again, the issues come up. Do you actually have standing? ANC can't sue, but as in the Kopff case they said, but ANC commissioners as individuals can. There were other issues. I want to do more than make a passing comment about what it was like to be carrying in essentially the White House load and the Secretary of HUD's load in the city when we had billions to spend on redevelopment. So I got a very unusual and inappropriate view of the respect that citizens like myself would get from the DC government, as I was carrying money, potentially. So I found a lot of respect accorded to my views. They weren't my views, they were the Secretary's views, they were the White House's views, they were the money of urban renewal and so forth, and housing. And in the Pennsylvania Avenue Development Corporation, as I sat through those meetings representing the two cabinet officers successively, I saw the power that can accrue when you overlay onto this city a special corporation. Pennsylvania Avenue Development Corporation, somewhat like urban renewal with its eminent domain rights, had absolute authority over a piece of geography on Pennsylvania Avenue. And citizens' views were secondary. When I read the opinion in this case, and I looked at Union Station Redevelopment Corporation, and with the marvels of Google, I punch it in and I say, well, where did this come from? And I see in I think it was 83, Secretary Dole, then the Secretary of Transportation, needed added powers to help do something about Union Station. So the answer was, we've got to just jam this through. We need a strong corporation with a lot of authority. Couple a strong corporate entity with the continuing desire of many, not all, in DC, maybe not even most, but of some in DC government not to recognize the ANC rights, and you've got the recipe for a challenge. And you've got a situation where the skills of Johnny Barnes are going to be called upon. So we have a situation where the Kopff versus ABC Board case had one resolution. It was taken up to the appellate level, and the concept of a three-party or three-part government was never more vividly demonstrated to me. The checks and balances of the Founding Fathers, putting the judicial system, the executive branch, and the legislative branch into a checks and balances system with each other. And three judges, Kelly, Nebaker, and Farron, sitting as en banc at the appellate level, took the ABC Board case, or the so-called Kopff versus ABC Board case, which is actually Judy Kopff, my wife, and Gary Kopff. She gets lost in the et al. That usually goes behind the lead plaintiff. But it was actually in that case, and I mentioned this bit of history only because it goes to one of the questions Johnny asked a minute ago. My wife had a different background than me. I had Colorado, Connecticut, and New York. She had Rhode Island and New York. But when she came to DC, she had had some experience that while we don't have all rights below the age of 21, we do have certain rights, and our families have more rights. And when we enter the District of Columbia, there's a very subtle transition that occurs. And it's not so subtle if you start clashing against DC government. And you think, well, that's not right, or I have rights. So the ABC board, when they took a particular action, Judy, I think, went either in person or it was by phone to the ABC board by telephone, and some woman who probably didn't identify herself, could have been a man, not significant that it was a woman, but said, oh yeah, the ANC thing, well, we don't follow that law here. By the time it got to the case, a man who was on the ANC with me later, he testified, and a more eloquent position was given by the chairman of the ABC board. And he said, we will accord you all the rights to which you're entitled. Paren, and we'll decide the rights to which you're entitled. Close paren. And because of a three-part governmental system, it wasn't really up to the executive branch and even the council and the corporation council to decide these issues. The courts weigh in appropriately when necessary and when there's a case that has standing and presents issues. And that's what Judge Macaluso has done in this important case. And what's astonishing to me, and I'll end my part here, is after 40 years have transpired, we still have situations where the attitude that perhaps Judy encountered and the gentleman I alluded to encountered in his testimony, people say, oh yes, there's that law, but it doesn't apply exactly here. Or you kind of knew anyway, so we didn't have to actually tell you. Or we knew what you had in mind, but great weight. I mean, you know you don't have a veto, so therefore, but therefore doesn't mean we can ignore you. It does mean you don't have a veto, but it does mean great weight has to be applied. And I think that was probably, I don't know if those words went back to Frazier or not. I suspect they did because they were in the original statute. They're not totally self-explanatory, but they invite justices, as in interpreting the Constitution, to breathe life into words and reinterpret it from time to time. And that's what seems to have occurred and may be occurring, and here I'll defer to those more familiar with the current case, even as in 2012 these issues come up again and come up in the second parallel and arguably more important area of environmental law. There are questions about what rights do exist. And those rights are not decided alone by the executive branch. They're not decided by powerful entities like the Pennsylvania Avenue Development Corporation, or in this case, the Union Station Redevelopment Corporation. Such entities are powerful, perhaps for good public policy reasons, but they are not leviathans, as they were called in the early pre-American days, that were given all power, as Hobbes wrote about them. The people are the possessors of the power, not the leviathan or the government. So the people's voice often has to be amplified, and amplified by learned counsel. Learned counsel are often too expensive for the people. On the other side of this case, I understand, were 3 lawyers from Covington and Burling. When I last dealt with them as an expert witness against, they were on the other side, they're paid $500, $700, $800, $900 an hour. I don't know if Johnny Barnes got paid the same. He was worth the same. I hope he did. But the worth of a man is not.
Their lawyers were very short.
The worth of a man is not the compensation that's given. But the judicial system does enable all parties to be represented, and Kopff didn't win Kopff versus ABC board, with all due respect to my wife and to me. Johnny Barnes helped win it, Bob Stumberg, Sari Marmer, who's now living in Atlanta, under the tutelage of Jason Newman, and with the support of the clinical law program of Georgetown University. Those resources came to bear to enable a test case, in which we just happened to be a reasonably appropriate test case, to go to court and to cause the judicial system to weigh in with the executive and the legislative to achieve a reasonable solution. So that's the history as I remember it. I may have erred slightly from your memories, which are both as long and undoubtedly greater. That's my concept.
Thank you.
Thank you.
It's amazing. Gary followed the rule of law and finished in 10 minutes. We're going to amend what I said earlier, and when we first engage you, after Gottlieb finishes, and assuming Jason is not here yet, I want to allow Judy Kopff 5 minutes to open up the discussion. Judy wrote a wonderful summary after having read the decision of the Macaluso of what it may mean for us across Washington, D.C., not just in Ivy City. So after Gottlieb, Judy, you'll have 5 minutes, so think about what you want to say. Go ahead, John.
Ask your question, that's what happens.
Tell them who you are first, what you do and all that.
I was, have to excuse me, my voice is not that good tonight. Among other things, as the director of the Office of Advisory Neighborhood Commissions, which is an independent office of the DC government, I provide orientation to newly elected advisory neighborhood commissioners. And I did that about a week or so ago. We had a Saturday, and I tried to introduce myself a little bit, and I explained that I had been working on these issues for a long time. As a matter of fact, since the Washington administration. And then I realized there were some people who were thinking of George, and I meant Walter. But I have been involved with the ANCs since that time, and for the last 11 or so years in the office at the Wilson Building. The ANC law says that before the government does anything significant for neighborhood planning or development, it should inform the affected ANC. And it lists some particular things that should be included in that list, but not everything. So we have had, from time to time, and more often than maybe we would appreciate, some amount of tension over whether a particular thing needs to be noticed to an ANC. And so this summer, I'm not going to try with the chronology. Recently, I'll say, the Deputy Mayor for Economic Development went through a process to locate a temporary, 5 to 10 years, spot to park buses that might otherwise have been in the vicinity of Union Station for good reasons for Union Station, okay? And they found this spot at Crummell School. Am I saying something that is new to anybody, or okay? But now what's interesting about their decision to locate this temporary activity at Crummell School, what's interesting about that from the point of view of ANCs is they weren't unaware, according to the record that Attorney Barnes was able to provide for us, they weren't unaware that there was an obligation to tell the ANC. They just decided not to. Now that's significant, okay? We've really come beyond the point where government officials are unaware that they're ANCs, although I do run into folks from time to time who are surprised I work for the African National Congress, but that's another story. They just don't always bother to follow through on that obligation. And I do get other letters from the Office of Deputy Mayor for Economic Development telling me about piddling little things that nobody really was that interested in, but they know to send those letters. And revealingly, they weren't necessarily condescending towards ANCs in general. This ANC was the one that they were condescending towards, ANC 5B. They didn't tell ANC 5B because they were concerned about another unnamed ANC's response to that. So there's a little bit of interest there as well. Folks, and those folks are Empower DC, and the neighborhood residents that Empower DC worked with said, once they became aware something was going on, said, there's something wrong with this picture, something's not right here, and so they went to court. Long story short is that we now have a preliminary injunction,
That's right,
which says You cannot go ahead and complete your intention to use that parking lot. You can finish the work, you can maintain the site, but because you didn't inform the ANC that you were planning to do this, you can't begin using it until the ANC has its 30 days notice. They also pointed out that there was some, the judge didn't use the word lie, did she? About the numbers?
Came real close.
She came real close?
Came real close.
The, I didn't know this, but the environmental laws of the district say that if you have a project and it reaches a certain dollar threshold, you have to do an EIS, environmental impact statement. And so when certain folks went down to fill out the forms, get the permits for this project, they had to put down how much it was going to cost. It was amazing. It was just under the threshold, right?
1.5.
And consequently, the EIS wasn't triggered. Afterwards, it was discovered that, in fact, the project was over the threshold. Imagine that.
Wow.
So, again, they have been told you can't proceed until an EIS is done,
Yes.
until the ANC gets its 30 days. And strangely enough, the city is even appealing this. We're still at the level where the judge has only granted a temporary injunction. We don't have a permanent injunction. We don't know how far appeals may go on all this. One of the conclusions that I draw from about this so far is that Attorney Barnes, Empower DC, and the neighbors in the area should receive great credit and great commendation for the work that they have done. And it is unfortunate that there may be neighborhoods in the city that have a similar need but don't have the same resources. This is, to my mind, the particular lesson that we're learning from this case, is that there is a need to support the ANC's ability to enforce the rights that they are guaranteed. Councilmember Berry has a bill which we had hoped would have gone through the legislative process by now. Unfortunately, a hearing was scheduled during the summer, had to be postponed, and has not been, and it has, we ran out of time. It's going to be, it's going to be reintroduced at the beginning of the next session. What is this bill I'm talking about? This bill that I'm talking about is the one that would remove the prohibition of ANCs going into court. In Kopff, the judges ruled that ANCs may not only may not go into court to protect the rights that the law says that they have a right to great rate, that they have a right to 30 days notice, and so forth. It says that individuals in their official capacity as advisory neighborhood commissioners can't go into court either. And that means that ANC resources, funds, typewriters, whatever. Did I say typewriters?
Yes. George Washington. Yeah.
At least I didn't say quills, right? They would be enjoined as well. None of those resources can be used. However, importantly, one thing it does say, and I say that intentionally tonight, because every so often, and just this week I got a question from a commissioner about doing this. A person who is a commissioner and a person who is a citizen of an area whose ANC's rights have been violated can go into court as individuals and as neighbors, because those rights that the ANC enjoys are actually understood not as the commission's particular rights, but rather the rights of the community for which the ANC is the agent. And when the ANC is unable to follow through on protecting those rights, they still remain with the individuals, the people, the community. And so they do have the avenue of going into court for those things. So I'm hopeful that the Ivy City case will provide a little bit more enthusiasm, understanding of the need for Mr. Berry's bill, when it's reintroduced next January, to receive citywide support and get early passage, so that other ANCs and all ANCs throughout the city will be able to effectively enforce their rights.
Thank you, Gottlieb.
Was that a lawful presentation then?
Yes.
Thank you.
It was
Thank
lawful.
you. Thank you.
You're very lawful.
Okay.
Judy, 5 minutes.
Hi, I'm Judy Kopff. Happy holidays.
Happy holidays.
I think it's really important to focus on the fact that grassroots organization really can have a powerful effect in your hometowns. That's how a lot of people, I don't know, that's how some people become members of Congress, because they start at the local level and then they work their way up. I also want to point out, I'm not an attorney, neither is my husband Gary. Gary and I both decided that we wanted to oppose a liquor license, a proposed liquor license that was for a bar at the foot of our street, 300 feet away from our house. That's how all of this started. That's why it's Kopff versus ABC Board. So the proposed bar was Ireland's Four Provinces, which has now been bought out by somebody else. When we saw the proposed license, there was a permit in the window. I remember coming home and saying to Gary, we have to fight this. And Gary and I both did surveys, and we wrote Gary is really good at PowerPoint presentations, and he did a PowerPoint presentation, and he showed that this would have been the 8th liquor license in a one-block area. There are probably now 15, but at the time, we were very much opposed to it. And I cannot remember how I knew about the Home Rule Act provision about the ANCs. I'm sure it was probably through Gary. But anyway, I can remember, as if it was yesterday, calling from my house the ABC board. And I got a woman on the phone, and I told her that she did not issue a notice to the affected advisory neighborhood commissions. There were 2 affected ANCs. And as Gary said, she said to me, oh, that just has to do with the Home Rule Act. We don't pay any attention to the Home Rule Act. I didn't slam the phone down or anything, but then somehow or other we found out about Georgetown Law School's DC Law Project, and Sari Marmur, who, M-A-R-M-U-R, became the main attorney at DC Law Project, who worked with us on the case, and the rest, as they say, is history.
Right.
Anything else you have to say?
Thank you.
Thank you.
Judy, you'd be,
Actually, just one comment.
Go ahead, Gary.
Picking up on the point that you made. When you reread, if some of you do, the Court of Appeals decision, it makes the distinction, as quite accurately described, that ANC commissioners and their commissions as a collective entity cannot sue. This is pre-Berry legislation, which of course has not passed yet. I'm not saying it shouldn't, I'm just saying it hasn't passed yet. But then they went on to say, as was accurately described, but the individuals who are the ANC commissioners can, together with other affected citizens. That's really important, because how many of you are ANC commissioners in the room? All right, 1, 2, 3, 4, 5 at least.
And get the retiree.
Or retired, okay. Well, we were elected because we have some interest in, and maybe responsibility toward, other citizens. Think what it would mean if you took persons who would step forward to become ANC commissioners and said, you can't appear on any pleading before the courts in your official or unofficial capacity. You've just robbed some of the more activist members of their rights. So it's important, even if the Berry bill were not to pass, that ANC commissioners can be actively involved. Yes, you probably can't use your typewriters or access to computers and so forth, but your leadership is your most valuable access. The knowledge that you possess and your commitment and your respect among the people who elected you. So you can be activists, you can be signatories or two or plaintiffs on pleadings that go to the DC Superior Court. And that's not trivial. There's better ways to deal with it, and I think, while I haven't studied the Berry bill, that would be rather extraordinary if that occurred. There would still be a need for resources. And I think the reason many of you might be in this room tonight is we don't all have Johnny Barnes, and the organization whose name I don't...
Empower.
Thank you, Empower. I'm
Empower
looking for
DC.
the word.
Yeah, Risa.
The Harrison Institute at the Georgetown Law Center and this organization, Empower, are wonderful. Not every ANC is going to find pro bono counsel. Even if you have the legal rights to get into court, you need to have resources. But one step at a time, and that seems like a good step to go beyond what didn't happen in 1973. And part of the resources is a meeting like tonight where ANC commissioners and others learn more, because the knowledge is really the more powerful resource. To put a stone into your slingshot and bring down a Goliath does require often a very skilled attorney like Siri Marmer and others, or Johnny Barnes, but you also need knowledge to get that sling and that little stone moving at a great pace into the forehead of the Goliath. So I applaud all of you for trying to increase your knowledge in this area.
Judy, you should know that I did invite Sari. She's a Facebook friend.
She's my Facebook friend as well.
Yeah, never expecting her to come up from Atlanta, but I invited her anyway. Particularly when I thought Bob was going to come as well, because we would have a little reunion, sort of unanticipated reunion. But so we're still waiting for Jason. We're going to get started. We have an hour to engage you, and anybody just raise your hand. I would only ask you to be sensitive to the fact that we want to get as many comments in as we can, and I will cut you off if need be. Go ahead, Judy.
Please excuse me, I got a little sore throat, so I may not be able to speak as loud as I should. Johnny, you know I've been fighting a lot of issues regarding the invisible diminishing of the ANC authority, and Gottlieb knows too, and has shared some of my concerns with people. Talking about ABC board real quick, there's a matter of them having a handbook online rather than the regulation. I raised that point a couple of years ago when we had a particular ABC case, and it was a zoning matter. I didn't know about crop, or else I would have pursued it from that perspective. The law says that before the ABC can issue a license, you have to meet the zoning qualifications. That's number one, blah, 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 and something else. I think it's 2 or 3 other things. What ABC did for this particular case that's pretty contentious in one of the single-member districts is that when the protesters raised this point that zoning, it was an old zoning, grandfathered prior and whatnot, it needed to have the new zoning before you can even issue a liquor license to this particular business, which will only be right for all the other stores that may convert from a R4 to a 2C, C2A or whatever. The response to our resolution by the ABC board is that that is not a matter under the purview of the ABC board. You have to go directly to zone. And they gave no regards to it because the correct zoning for the liquor license, it was currently an R4, and they still went ahead and issued a liquor license for R4 zoned store business. And it raised a lot of, I had a lot of concerns about that. And just briefly, Mayor Berry did introduce the bill, the ANC Empowerment Amendment Act. A hearing was scheduled on a Saturday morning about 11 o'clock at the Wilson Building, second week Saturday in June. About 20 20 witnesses were there waiting for him, and he seemed to have gotten tied up in traffic and couldn't make it over after 3 calls. We scheduled it, I think it was October, it was rescheduled to or something like that, and then abruptly canceled. There's particular concerns about that bill because it's very broad, and wondering your views on the fact that once the redistricting commissions start, and we have commissions now that are a lot smaller. We used Ward 5 had 3 commissions, 12 commissioners. Now we have 5 commissions, 6 to 8 commissions. That means the funding is going to be lower. So my testimony for that particular bill that hasn't gotten on the official record stated that if this bill does pass, that a pool of funds be set aside for ANCs to access to pay for legal matters, because the funding he receives are basically for operations. So if you're only getting about maybe $12,000 a year now, as opposed to my ANC got like $29,000 the last time a year, and you know, with the quarterly $8,000 or whatever quarterly allotment, and you're getting much less now and have other expenses. Some ANCs have to pay rent, whatever. How can you afford legal fees? To pay legal fees out of that funds, and say you're sued or there's a countersuit, who pays? So that's kind of left open in that bill.
Thank you for sharing those things, and Gigi, we appreciate that. Gentleman in the back had his hand.
I'm gonna sound like a killjoy.
Okay.
The problem is there are really 3 issues. One are procedures, whether or not the government follows them. Another are the remedies. Because if it doesn't matter if you're consulted, if there are no remedies in the laws or regulations to give you any substance to your weighing in. And I'll give a couple examples of that. Bowser did a law that requires demolition notices for ANCs, demolition permit notification. But there's only one remedy in DC law to prevent a demolition, and that is to designate the property historic. And for a variety of reasons, in 98% of the instances, you can't use that. So there's no remedy. So who cares if you're notified?
Why
There's
do you say
nothing
you
you
can't
can
use
do.
that? Why don't you explain that? Why do you say you can't use that?
Well, I don't want to explain to you for an hour about how the historic preservation law works and how the HPRB has to only, it has to meet for an individual building to meet the requirements of the other laws, historic preservation laws, to be designated, to be deemed worthy of designation, is really high criteria for an individual building to meet. It's not as part of the historic district, it's much looser. But for an individual building, which is what would be relevant for an individual building being a demolition permit, you can't do anything with it. Just like in this particular case, the only thing that really matters is that an EIS is required and that they didn't do it. And if the EIS says, if I don't know the EIS requirements well enough to know what's deemed bad, but if it won't be deemed a noxious use, then the preliminary injunction doesn't matter. And so the issue is, we can't just merely be content with our rights as citizens to be heard. We have to have real substantive remedies available to ANCs, available to citizens. I mean, the Home Rule Charter is all biased in favor of the executive. So it's like there are almost no remedies for citizens, and regardless of the office of ANC, there's almost no substantive training for ANC commissioners to be any good at what they do or to know anything. And also, the fourth point is ANCs then have to take the responsibility to be fair seriously and to follow due process and all that themselves. Because there are plenty of examples, especially in Ward 5, of ANCs being nefarious. So as far as citizen involvement's concerned, as far as being fair is concerned. So I think this is good. My real argument would be the EIS procedures in DC suck. They don't favor citizen protection. That's the real issue, and hopefully this will help us move towards it. But you know, I think in the end that thing's going to be built. So you know, I'll leave it at that.
Well, I'm anxious to lift you up because the case really does. And let me just say, I'm going to go to Parisa though. I know she's anxious, and I'm going to come up to Phil next. But let me just, and then let me just say that that thing ain't going to be built. Write that down. Go ahead, Parisa.
Yeah, I understand what Richard's saying in terms of not having adequate remedies in the law, which I agree, and that's why we can't count on the law alone. This has to be part of a citizen movement. It has to be part of a grassroots strategy. There have to be masses of people showing their political power, building their political power, and that's why in Ivy City, in a way, the reason why this has been successful is because the community was already organizing. And Richard knows this because I worked with him 10, 11 years ago in Ivy City. So I never stopped. And so we've been fighting for the same building and the same issue, the same concern, and building leadership all the time, no matter how long it takes. In a way, the mayor played into our hands by doing something so nefarious, as to use your words, because he couldn't. It wasn't enough that he's got buses parked all over this, all over that area. He had to go for the center of the community. He had to go for the historic site, the building that was promised to be the centerpiece of revitalization and the rebuilt community. So I think that we have to also acknowledge that, yeah, we can't rest on lawsuits alone. Unfortunately, groups like Empower DC, we don't have the money to pay Covington Burley, much less even Johnny Barnes. Johnny Barnes practically donated his services to us. This was not in our budget. We did not know we were going to have to sue the mayor. So that's unusual that we get that opportunity to work with somebody with such skills and notoriety as attorney Johnny Barnes. We were lucky he felt the case. So it really, what it comes down to is if we have people who are making it politically impossible for them to do this, then they won't be able to move forward. If we get to the point where people are doing sit-ins and people are doing direct action, and my real concern is that I don't see enough of that given, what's going on? They're about to close 19 more schools. We already went through this 4 years ago. Are we ready to do a sit-in now? Because we already know it's not going to improve education. We already know it's not going to work. We already know what it's about. So my big thinking there is, yes, we do need better laws, but we also need more organizing.
Yeah, all right.
Okay. I'm going to come back to you, Richard, because the case does much more than you believe it does, but I don't want to.
And I think Jim knows also at some point. I think Jim knows more about the EIS.
Okay, go ahead, Phil.
Yeah, I'd just like to follow on what Parisa said. This mayor became mayor because many people in this city thought that we were being treated with utter arrogance by the previous mayor. If there is a mayor in the history of this city who should know the dangers he's running by doing what he's doing and then compounding it, having another parade of incompetence before a new judge as he appeals this, well, I don't know how that happens. And if somebody could help me understand why is it that this mayor and certain members of this council are slitting their own throats with a rusty razor?
Good question. My friend here and then Gottlieb.
All right. Natalia Stracuzzi, thanks for having the meeting and having me here. I'm going to give you the smoking gun. The fact of the matter is DC puts out a planning projected, it's a 10-year plan. And what I've been noticing since I was running for office, I would get all these different ANC meetings. What I would notice is the 10-year plan gets changed after the period has been passed. Now you have to do a economic environmental study, you have to do a VDOT study, you have to do an impact study and such in these type of events. So these things have been paid for this plan. And what's happening is they're rezoning it after the plan's been put in place. Now, this can't happen because, again, this was approved by the city council and everybody else, but Department of Planning itself is taking it on itself to give carte blanche to whoever's in the area.
Right.
And this is where you really stop them. And I brought this up at a cathedral, at 2500 Cathedral one evening, about one point. First of all, they were going to pass at that area. This part of the neighborhood has a big market value for home businesses because law firms can come in, chiropractors, all these different type of business, lobbyist firms. These homes in these neighborhoods are valuable to the city for business use, not residential use. So what they want to do is they want to give people, they want to do away with the fact that you no longer have to have a hearing to remodel your home or make changes to it. And they want to give it to the residents, which would be great for the residents because the residents then wouldn't have to file for a hearing. They could just submit their plans to planning. They could approve it or deny it or tell them what they need to change it and go for it. But what they want to do is they want to give it to the businesses and to the residents so they can bring more commercial, small impact business, they say, into those neighborhoods that have a high dollar value to those type of businesses. But the thing that's not being done that really I think can stop them is the fact of the matter, and I brought this up numerous times, that this is illegal. They are not posting the notice, public notice hearings. Where do you see hearing notices around projects that have been started? You've never seen it. They take a picture of it or they say they mail something out to somebody, but the notices aren't being posted. And this is where you stop them. As he said, how'd they find out about it in '73? You saw a notice in the window, or you saw there was a notice about it, and you found out what it was, correct? Yes. This is how they're changing our city on us without letting us know. Because, come on, where are the signs for notices? There's all kinds of stuff changing in the city. Where have you seen those big white, orange, or whatever signs they used to post on fences or in front of the properties? They're not there. And this is where you stop them, and you stop them in their tracks because they are breaking the law. They have an obligation to the community. Even if the ANCs are involved or not involved, the neighborhood and the community has an obligation to know what's going there. Did you all see anything in Ivy City? Any type of notice that they were going to make changes there? Were there any notices in Ivy City?
Not until they started construction.
That's right. Because again, this is where they're breaking the law. And this is our government that's doing it. Our government doesn't understand that the people make this city, not the businesses. And again, they have to start looking at the residents as the truth. And the same with the Social Security, and that's why I ran for Congress, but I won't get into that. It's the working class that supports the world. And the residents of this city support this city. And they make this city. So this is where you stop them.
Thank you for that. We're going to go to Gottlieb. There's a lady in the back, and then Jim in the front. He'll tell you about the environment. Go ahead, Gottlieb.
I wanted to make 2 points. I resonate very much with what Richard was saying about rights need remedies. I think a right without a remedy is a wrong. The fact that, however, in this Ivy City case, we were able to get an injunction is in fact a very useful thing because in almost all of the cases I can think of where ANCs have succeeded in getting injunctions, this is not the second time this has happened, that time period has been very useful in organizing, in getting lobbying, and frequently you don't have to go to the next step because there has been an opportunity to exert influence, and so whether or not a court is going to grant you some compensation hasn't been necessary because it's been taken care of in other ways. Not always, don't want to be Pollyanna about it, but the mere fact that you got time to organize is important. But there's a second thing that we haven't been mentioning or focusing on, and that is that 30 days also grants the ANC the opportunity to provide comment and then great weight, okay? I haven't defined what great weight is, so I'll do it quickly.
Sit on the merit.
What's that?
Sit on here.
Great weight. He said, sit on the mayor with great weight.
Oh, I see.
Sit on him.
Okay, all right. That's the image that phrase usually generates, is that there's a balancing act that goes on. In the ANC law, great weight has a technical special meaning, and it says that a decision maker has to do 3 things when they come to issuing a decision on whatever the subject has to be. Number 1, they have to identify with particularity and precision what the issues were that that are being brought up. And let me say parenthetically, these are points that were initially articulated in the Kopff decision, but have since then now been incorporated legislatively into the law. Second, the decision maker has to say that those points, those issues, those concerns are in fact attributable to the ANC. The third thing, and this is the good one, this is the especially important thing, is the decision maker has to say why the ANC's advice was not persuasive. So now this opens the door to further lawsuits in the event that there's not a good match between what the ANC said and the reasons that the decision maker gave for not accepting them, because those other magic legal words come into
arbitrary
mind.
and capricious.
Okay? And courts can, in fact, tell agencies of the government to do something or undo something. I remember in this neighborhood, Blackie's House of Beef. I seem to recall that once upon a time there was a big sign on top, and it was there in violation of the zoning. And they said, but it would cost so much to take it down. That would be so unreasonable. Well, the law is about the law.
That's right. Good point, Gottlieb. Good points. Yes.
Good evening. My name is Mercedes Arnold, and I work for council members in 5 and 7. And right now, I'm speaking on behalf of myself as an attorney that lives in Ward 5. Gigi is in my ANC. The issue that brings me out tonight is something that deals with my own neighborhood, but something that has made me get familiar with the work that I did when I worked for City Council. And the first thing that I need to express is a strong desire that groups like Empower DC participate in the process of defining what is and is not in the comprehensive plan. Because while this decision is fantastic, when the government does something that is inconsistent with the comprehensive plan, as a matter of, I believe, law, correct me if I'm incorrect, they bear the burden of explaining why it is consistent with the comprehensive plan. So the comprehensive plan, as the gentleman alerted to, is a document that is put together by the citizenry. If you show up and say what I want in the comprehensive plan, it's going to be real hard for people to say nobody wants what isn't there. The next thing that I really want to strongly emphasize is that the ZRR is the catchphrase for the zoning regulations review. And the ZRR is a process that is going on right now to change the ability of individuals from their traditional ability to appear before the zoning commission and appeal zoning commission's decisions to have to go through higher legal hoops in order to get their voices heard. So I would encourage and I would ask for Empower DC to help us with our review of the ZRR, because the zoning regulations review, for example, is changing the zoning commission's procedures such that if you are not a party to a proceeding, and a party is a term of art in the law, then you cannot appeal the decision of that proceeding anymore. Now, that's important. Okay, that's very important from a legal standard. I'm not here to give legal advice, so I'm not going to go deep into that. The fourth or the third thing that I want to bring to your attention is the balkanization of the different agencies in our government. I went to a meeting with the sage up front from Ward 5, and
That's because it's great here.
no, I said sage.
I get this way because I've gone to more than you have.
Yes, indeed. I'm
3
learning
more
from
and
you.
you'll.
Learn from you. But the point is, we had an issue with respect to residential zoning around what used to be Colonel Brooks. And the Department of Transportation was there. And it's very interesting that the different agencies will shift the ball. Oh, this is not a zoning issue. This is a transportation issue. This is not a zoning issue. This is an ABC issue. Okay? Now, sadly, when you go to the hospital, the doctor of the heart will not talk to the doctor of the foot. And the doctor of the foot will not talk to the doctor of the lung. And the doctor of the lungs will not talk to the doctor of the kidney. And unfortunately, and sometimes, the patient dies. Now, as our city is a holistic whole, I don't want to be told that I missed my opportunity before the zoning commission because I thought it was an ABC issue. Okay? I don't want to be told that I missed my opportunity not to have parking meters in front of my house because it was a Department of Transportation issue. How many ANCs actually have a subcommittee that does nothing but follow ABRA, DDOT? You know, you almost need to have your own administration. And so to the degree that we could support legislation that provides Gottlieb's office with training in all administrative matters, not just ABRA, not just DDOT, not just, I think that would be something to get behind. And I had one more point which I forgot, and I'm really sorry, because I think it would be really helpful to people who are interested in working in the community. But
well, those are really good points.
Thank you.
Hi, I'm Jim Doherty with the Sierra Club. I practice environmental law for a living. I got a call from Parisa today saying you should come to our meeting in the West End Library about ANC procedures, and I said, sorry, I'd rather go to a Christmas party, which I just did. And then she said, well, you should know that Johnny just won an injunction in the DC Environmental Policy Act against the parking facility. I said, are you serious? I will be there, because this has been a matter of great interest to me since the law was